All right, folks, you know how we always talk about accountability in public service, right? Like, gotta be more than just talk. Well, buckle up, because today we're diving into a Supreme Court case that really throws a spotlight on just how important that actually is in practice. It's a case that, kind of makes you think, what happens when public assets, things that belong to all of us, are seemingly sold off for, like, way less than they're worth? And when the people in charge, the ones we entrust with our resources, seem to just sidestep the rules meant to protect those resources, well, that's a problem. And this case really digs into that problem. So we're going to unpack all the juicy details, the arguments that went back and forth, and what the Supreme Court ultimately decided and what it might mean for, the future.
Okay, so right off the bat, let's introduce the main players in this whole saga. We've got Danilo Reyes Crisologo, who at the time was the president of the Philippine Aerospace Development Corporation, PADC.
Oh, the PADC. Yeah.
Exactly.
Mhm.
And alongside him, we have Roberto Loleng Manlavi, PADC's senior vice president back then.
Okay, so these are the guys in the hot seat. What exactly were they accused of doing? What landed them in court?
Well, they were charged with violating Section 3E of RA 3019. That's the Anti-Graft and Corrupt Practices Act. The accusation basically boils down to this. Between 2007 and 2008, they allegedly cooked up a scheme, conspired, if you will, to give undue advantage to a private company called Wingtips Parts Corporation.
Wingtips Parts Corporation.
Yep, that's the one. And how did they allegedly do this? By selling off PADC aircraft spare parts, accessories, equipment, the whole shebang, at a price that supposedly caused a huge loss to the government.
So basically selling off public assets for pennies on the dollar. That's a pretty serious allegation. Just how much money are we talking about here? And what specific rules were they accused of breaking?
Well, the prosecution argued that these sales to Wingtips were all done through negotiation. Now, that right there raises eyebrows because, you see, both the COA, that's the Commission on Audit, and PDC's own internal rules, specifically their revised pricing policy, required a 30% markup on any locally sourced parts.
Okay, a built-in profit margin to make sure the government isn't losing out seems reasonable.
Right, exactly.
Yeah.
But according to the charges, this 30% markup was completely disregarded. And we're not talking about chump change here. The alleged loss to the government was pegged at a minimum of 6,246,635 pesos. That's the difference between what they actually sold the stuff for and what they should have sold it for with that mandatory markup.
Yikes. That's not a small amount. Before we go any further, can you give us a bit of background on PDC? What exactly does this corporation do?
Sure. As I mentioned earlier, PADC stands for the Philippine Aerospace Development Corporation. It's a government-owned and controlled corporation, established by Presidential Decree number 286, later amended by PD 696. Now, their main gig is aircraft repairs. But they also deal in selling aircraft spare parts, which is where this whole case comes in. And as we said, they had that revised pricing policy in place, that 30% markup rule, which came into effect on September 4, 2006.
So the rule was already there, clear as day. How did these sales to Wingtips even happen then? What were the key decisions, the turning points that set this whole thing in motion?
So this is where it gets really interesting. On November 16, 2007, Manlavi, remember him, the senior VP, he issues a memo. And this memo proposes a whole new set of guidelines for how they value PADC spare parts. And guess what? These new guidelines suggest significantly lower values, especially for parts that don't have proper documentation, parts that are not on the manufacturer's list anymore, or parts that they consider, quote-unquote, depreciated.
Oh, I see where this is going. Depreciated parts, lower value, more room for, shall we say, creative pricing.
Got it. And here's the kicker. Crisologo's signature is right there on that memo, right under Manlavi's. This document becomes Exhibit A in the whole case.
Oh, so they've got this memo setting the stage for lower prices. What happens next?
Well, between February and July 2008, PADC goes ahead and carries out 7 separate transactions with Wingtips, selling off these aircraft parts. Now, naturally, when a government corporation starts selling valuable assets at a loss, people start asking questions.
Makes sense.
And those questions led to a full-blown COA investigation, which kicked off on June 15, 2009. The COA was specifically looking into these PADC Wingtips deals, suspecting some serious irregularities.
Okay, so the COA steps in. What did their investigation uncover? What were the smoking guns, so to speak?
The COA came out with their fraud audit report number 2010-008, and let me tell you, this report was not pretty. First of all, it confirmed that, yep, The sale prices for those spare parts were indeed lower than what PADC's own pricing policy dictated. And get this, it was done without any expert coming in to assess the fair market value of these parts at the time of the sale.
Cutting corners much.
Seems like it, but it gets worse. The report also found that these sale prices were basically decided by Manlavi alone based on his, let's say, convenient new valuation guidelines. And he did this without getting the necessary approvals from PADC's board of directors.
Going rogue, huh?
Pretty much. And there's no evidence that any expert was ever consulted to determine the actual condition of the parts before they were sold off.
So no due diligence whatsoever.
Nope. And here's another thing. The COA made it clear that these parts couldn't be considered scrap, obsolete, or worthless. Not by a long shot. They were classified as brand new because they were still sitting in PAD's stockroom, still listed as part of their inventory.
Interesting.
Yeah. And the report even pointed out a basic accounting principle. Inventory stuff you got on hand to sell isn't subject to the same depreciation rules as, say, a building or a piece of machinery. The audit also raised a few other red flags. They questioned the decision to bring in outside consultants to manage the stockroom instead of using PADC's own personnel, who are, supposedly bonded and accountable.
Okay, so lots of procedural missteps. And on top of that, they brought in outsiders to handle valuable assets.
Yeah, it definitely raised some eyebrows.
Yeah.
And there's more. The COA also noted that PADC had started using computer-printed receipts instead of the official serially numbered receipts, which can be a sign that someone's trying to manipulate the books.
Okay, so the COA report paints a pretty damning picture. What about the people who testified during the trial? Did they add anything to the story?
One of the key witnesses was Arsenio S. Reyes, Jr., a COA state auditor. His testimony provided valuable insights into the audit process. He explained that COA auditors primarily verify the initial cost of the items when they're acquired. It's the management's job to assess the current condition of those items and to justify any price reductions to the COA, especially if they're claiming obsolescence or damage.
So it's a checks and balances system.
Precisely. Reyes also clarified that while COA representatives aren't required to be present for every single sale, the agency head, meaning the PADC president in this case, is ultimately responsible for managing and disposing of the organization's assets. Reyes specifically mentioned that they issued an audit observation notice of charge, number 2009-001, which directly addressed the 2008 sales and flagged the fact that PADC was selling these parts at a loss.
They were formally notified that something was wrong.
Yep. And they even issued a memo, number 2008-10, recommending that PADC immediately stop selling parts at a loss. The problem was, according to Reyes, PADC didn't provide any documentation to back up their pricing or their claims about the so-called net realizable value of the parts.
So basically, no paper trail to justify their actions. What about the other side of the story? What did Crisologo and Manlavi have to say for themselves?
Both Crisologo and Manlavi filed something called demurrers to evidence. Basically, they were saying, even if everything the prosecution says is true, it's still not enough to prove we're guilty beyond a reasonable doubt.
A bold strategy.
It is. Crisologo argued that there was no direct evidence tying him to this alleged conspiracy, apart from his signature on some documents. And he claimed that crucial witnesses from the COA investigation team weren't brought to court. His main defense was that the parts were obsolete, and that the money from the sale ultimately benefited PADC. Manlavi, on the other hand, argued that there was no proof the parts were brand new. He claimed there were no consultations with aviation experts to properly assess the condition of the parts. He kept saying they should have considered the net realizable value, which takes into account the current market value, for potentially old or slow-moving stock, rather than just the original purchase price.
So basically they were saying, look, these parts were old, they weren't worth that much anyway.
Right. And Manlavi added that older stock naturally sells for less, and obsolete parts are basically worthless anyway.
Okay, so they tried to shift the focus to the perceived value of the parts. What was the prosecution's response to that?
The prosecution wasn't having any of it. They shot down that obsolescence claim, pointing to all the irregularities surrounding the sale. They emphasized that there was no board approval for the new pricing guidelines. They used a negotiated sale instead of the mandatory public bidding process, and the prices were ridiculously low, clearly violating PDC's own policy. The prosecution's argument was, look, all of this clearly caused harm to the government, and you can't just wave your hands and say good faith when you've broken the rules.
Makes sense. You can't just ignore the rules and then claim innocence because you thought you were doing the right thing.
Exactly.
Yeah.
And they added that Crisologo's rights weren't violated during the COA audit. They stressed that the audit was just a fact-finding exercise, separate from any administrative or criminal proceedings.
Okay, so the stage is set, the arguments are presented. What was the verdict from the Sandiganbayan, the anti-graft court?
Well, on November 29, 2019, the Sandiganbayan issued their decision in criminal case No. SB 17 CRM 0168, and they found both Danilo Reyes Crisologo and Roberto Loleng Manlavi guilty of violating Section 3E of RA 30019.
Guilty as charged. What was the sentence?
They were each sentenced to 6 years and 1 month to 10 years in prison. And that's not all. They were also permanently barred from holding any public office in the future.
Wow, so a pretty hefty sentence. Why did the Sandiganbayan decide to hand down such a harsh punishment?
The Sandiganbayan really emphasized the fact that the main way to dispose of government property is through public bidding. Negotiated sales are only allowed in very specific and justified situations, which, in their view, didn't apply here. They determined that ignoring the established rule showed clear bad faith and bias on the part of both Crisologo and Manlavi.
So they didn't buy the "we were just trying to help" excuse.
Not at all. They also rejected the argument that the parts were obsolete. They pointed out that these parts were sold to a company that specifically trades in aircraft parts, which suggests that, hey, they must have some value. Plus, the parts were still listed in PTDC's inventory. The Sandiganbayan also highlighted the fact that Manlavi's new pricing memo and Crisologo's approval of it were done without the PADC board's okay.
Overriding established procedures. Exactly. And in the end, the Sandiganbayan calculated that PADC lost over 6,640,000 pesos because of these shady deals.
Okay, so a guilty verdict and a significant financial loss. Where did the case go from there?
Well, Crisologo and Manlavi weren't satisfied with the Sandiganbayan's decision. So they took their case to the highest court in the land, the Supreme Court.
Makes sense. Everyone has the right to appeal. What was their argument before the Supreme Court?
The main issue they raised was whether the Sandiganbayan made a mistake in finding that they acted with clear bias, bad faith, or extreme carelessness when they sold those spare parts. They basically argued that their actions didn't actually harm the government or give Winchips any special favors, which are essential elements for proving a violation of Section 3E of RA 3019.
So they were challenging the very foundation of the guilty verdict. And what did the Supreme Court have to say about that?
In a decision dated June 27, 2022, written by Justice Lazaro Javier, the Supreme Court reviewed the case, GR number 2533207, People of the Philippines versus Danilo Reyes Crisologo and Roberto Loleng Manlavi, and guess what? They decided to uphold the Sandiganbayan's decision. Crisologo and Manlavi were still guilty.
The Supreme Court agreed with the lower court. What was their reasoning behind that?
Well, first off, the Supreme Court confirmed that, yeah, both Crisologo and Manlavi were public officers, which is the first requirement under Section 3E. Then they moved on to that tricky second element, manifest partiality, evident bad faith, or gross negligence. They clarified the rules on how government property should be disposed of, as outlined in COA Circular Number 89296. They acknowledged that public auction is the preferred method, but negotiated sales are allowed in certain situations, if there's a good reason.
So they weren't necessarily against the idea of a negotiated sale itself.
Right. And here's the interesting part. They actually agreed with the defense that the spare parts in this case could potentially fall under the exemption for, quote, inventory held for sale in the regular course of business. They cited Presidential Decree 696 and the general policy of giving GOCCs some flexibility in how they generate revenue.
So it seems like the problem wasn't the negotiated sale itself, but how it was handled.
Exactly. The Supreme Court made it clear that this finding didn't let Crisologo and Manlavi off the hook. They pointed out that Crisologo approved those new lower pricing guidelines without doing any checks and without involving the PADC pricing committee or the board of directors.
Basically acting unilaterally.
Yep. And of course, they completely disregarded the existing 30% markup policy, which led directly to that big financial loss. The Supreme Court also rejected the argument that the parts were obsolete. They said there was no proof, especially since the parts were still in PADC's stockroom. Again, they emphasized the accounting principle that stuff in inventory isn't usually subject to depreciation.
So that argument didn't hold water.
Nope. The Supreme Court also brought up Crisologo's failure to explain why they hired outside consultants for the warehouse and why they used unofficial receipts. And finally, they pointed out that they only negotiated with wingtips without even trying to find other buyers who might have offered more.
So it wasn't just one thing. It was a whole pattern of behavior that raised red flags.
Exactly. The Supreme Court said that all of these actions showed a clear inclination to favor wingtips, and they said it showed a deliberate intent to do wrong or to cause damage to the government.
Which basically means bad faith and gross negligence.
You got it. And then, of course, there's that third element of Section 3E, undue injury to the government or giving unwarranted benefits to wingtips.
Right, because even if they messed up procedurally, if there was no actual harm, it wouldn't be as serious.
True. But on this point, the Supreme Court was very clear. They said that wingtips definitely benefited unfairly by getting those parts at ridiculously low prices for a song, as they put it, and they agreed with the Sandiganbayan that the government, through PPC, suffered a huge financial loss. They also pointed out that Crisologo and Manlavi didn't show that they properly considered things like market decline or followed the rules in the government auditing and accounting manual. Instead, they just set the prices themselves, without any authority and against the rules.
So a pretty clear-cut case of wrongdoing.
Yeah. And in the end, the Supreme Court upheld the Sandiganbayan sentence. 6 years and 1 month to 10 years in prison for both Crisologo and Manlavi, plus a lifetime ban on holding public office.
Wow, that's a strong message about accountability.
Definitely.
Yeah.
This whole case, GR No 253327, People of the Philippines versus Danilo, Reyes, Crisologo, and Roberto Loleng Manlavi, decided on June 27, 2022, really drives home the point that we need to strike a balance. We need to give GOCCs the flexibility to do their jobs and generate revenue, but we also need to hold them accountable and make sure they follow the rules.
Accountability and transparency. Those are the key takeaways. What do you think, folks? What are your thoughts on this case? Does it make you think differently about how public assets are managed? Let us know in the comments below. And if you found this deep dive insightful, don't forget to hit that like button.
To recap the key legal doctrines that came out of this case, we have, first, to prove a violation of Section 3E of RA 3019, you need to show that the accused person is a public official, that they acted with obvious bias, bad faith, or inexcusable carelessness, and that their actions resulted in harm to the government or gave unfair benefits to a private party. Second, the standard way to dispose of government property is through public bidding. Negotiated sales are an exception, but they need a strong justification. GOCCs do have some flexibility in how they operate, but they still have to be accountable and follow the rules. Items in inventory aren't subject to depreciation in the same way as other assets. And finally, evident bad faith means having a dishonest motive and knowingly doing something wrong, while manifest partiality means showing clear bias towards one party over another.
If you're interested in exploring more cases like this, cases that have a real impact on the Philippines, make sure to subscribe to the Deep Dive. We'll keep bringing you these deep dives, analyzing the big legal decisions and what they mean for all of us.